Hi, my name is Steve Parr, and I'm an estate planning lawyer in Vancouver, British Columbia. And I want to speak with you today about power of attorneys. Power of attorneys are one of the two key planning documents that people usually put in place when they are taking on incapacity planning. So that is planning for a time in their lives when they are physically or mentally incapable of making decisions on their own, and so they need to entrust that authority into the hands of a family member or a loved one. So a power of attorney covers legal and financial matters. So a power of attorney can be used in dealing with banks, with lawyers, with dealing with all kinds of different situations. So there are two types of common power of attorneys. One is called just a regular power of attorney or a general power of attorney, and the other one's called an enduring power of attorney. The difference here is that a general power of attorney will only last for so long as you are still mentally or physically capable. That is, as soon as you are incapable, it is no longer valid, which kind of defeats the purpose of having a power of attorney in the first place, because you're generally not going to rely upon another person to make legal or financial decisions on your behalf while you are still capable of making them yourself. There are some exceptions, of course. So generally, you're going to want to create what's called an enduring power of attorney. And an enduring power of attorney will allow you to grant that authority and will endure after the point in time where you become mentally or physically incapable of making those decisions on your own. Everybody should have one of these things. Everybody needs an enduring power of attorney, and the reason why some people don't get it is because they think that simply transferring their assets, whether it's their car or their house or a bank account, into a joint ownership or joint tenancy is sufficient. So that's simply not the case. So if you were to become mentally incapable and then you had a house that you owned in joint ownership, and your husband or spouse wished to sell that asset, they would not be able to do so unless they had an enduring power of attorney that you had granted to that person. So it's very important that these documents get done before the time occurs when you're no longer able to actually make these documents. Because after the point in time when you're no longer mentally capable, of course, by then it's far too late. You're not authorized, you're not legally able to make these documents. Who should you appoint in your enduring power of attorney? It needs to be somebody who's a family member, generally a spouse or a close family member, a sibling. Of course, it doesn't make a whole lot of sense to appoint somebody who is older than you because of the possibility that person may predecease you. You are likely going to want to appoint a spouse, and then as an alternate, a son or a daughter. Last thing you should know about an enduring power of attorney is that it has specific witnessing requirements. So within British Columbia, the Land Title Office will only accept certain power of attorneys that have been properly witnessed by a notary public or a lawyer. So make sure that you attend to that detail when you are preparing your enduring power of attorney.